So good morning, friends. So welcome all of you back to the second week of our program. And let us continue from where we had left. We had actually discussed certain provisions of DPDPA 2023 in the last week. Basically, we spoke about the applicability um, of DPDPA as applicable to personal data generated within India with certain exemptions, some of which we specified, and maybe the rest you are already studying in the um, law. We also stated that liability is on the data fiduciary with additional compliance responsibility for somebody who can be called the significant data fiduciary. Data principals have some rights and they have to be protected by the data fiduciaries. Then we also looked at the obligations of the data fiduciary. One is that no personal data shall be processed except with an approved legal basis, which could be consent, legitimate use. Notice and consent is the key compliance requirement. All rights shall be protected with appropriate technical and governance measures. Then certain compliance measures are applicable to minors and disabled persons. Appropriate risk-based security safeguards shall be applied. Data breach shall be notified. Transfer of data outside India or to a processor needs to be taken as a responsibility of the data fiduciary, and he should exercise due diligence. Same way, AI usage also is subject to exercising of the due diligence. It's possible that some more questions remain in your mind. So we will try to address it as we go along. Because today we are going to discuss, today and tomorrow, we are going to discuss that as a data fiduciary, how do we implement the technical and organizational measures? And during this week, both today as well as tomorrow, we are bringing in some industry experts to share their experiences. Today, Ramesh Venkatraman will be there in the second session, and tomorrow I will be having a panel of two persons, one on AI and another on banking. And obviously, I also look at all of you to participate in the discussion and contribute. Okay. Then next week, we will be exploring about the audit and assessment. At that time, some of the things which you would have omitted in the earlier discussions on DPDPA last week, such as the DPDPA rules, we will cover it before we get into DGPSI frameworks. Hopefully, in the next 1 week, government may come up with some more clarification on the rules. I don't know. But anyway, we will discuss the DPDPA rules separately when we start the third week discussion. So now coming back to this topic of discussion today, I've called it as compliance by design. Okay. The steps in compliance as far as DPDPA is concerned should start with identification of what part of data which we as an organization is handling comes under DPDPA. That should lead to creating an inventory of what I call as DPDPA protected data. That is, not all data which are in our hands come under DPDPA. That everybody understands. But in terms of implementation, have we segregated data which comes under DPDPA from data which does not come under DPDPA becomes the implementation issue. So whatever comes under DPDPA, I am calling it as DPD or DPDPA protected data. Okay. Now, we need to conduct a risk assessment, and based on the risk, we need to design a system which will be compliant by design and default to the provisions of DPDPA. That is the next step in compliance. When we enter into this risk assessment, we need to also identify the role of the organization. Are we a data fiduciary? Are we a significant data fiduciary? Are we a data processor? Or more appropriately, are we all the three in some parts? That makes the whole thing more interesting than otherwise. Now, if so, how do we determine our compliance requirements? As a data fiduciary, as a significant data fiduciary, as a data processor, or as a combination? This is one of the challenges which we face. Um, and of course, DGPSI does look at it and then try to provide a solution. Now, the next step in compliance is to develop the governance system with policies. Sometimes we may have to modify the existing policies. And once we have the set of approved policies, we need to communicate it to the stakeholders, obtain their confirmation. See, when we come to this modification of the existing policies, you will come across some kind of a resistance because people will say, I already have a policy. And there are some organizations which may say currently our policies are governed by some, say, director or somebody. I cannot go back to him and ask for modification of the policies. These are all internal issues an organization needs to sort out if they want to be in compliance. Then last comes the implementation of technical controls, and having implemented, review it, test it, then if necessary, correct it. At that time, you can make use of an external audit and also get certified. So these are the steps in compliance which we need to identify. Now, a system ready for compliance is what we call as DGPMS, that is the Digital Governance and Protection Management System. Just as you call something as ISMS, a system which is ready for ISO 27001 compliance, so you call it as ISMS. We would like to build a system which is, of course, a combination of people, network, as well as the devices. That system, which is geared towards compliance of DPDPA, is what we are calling as DGPMS. So DGPMS, by definition, is a system where compliance by design is built into it. Now, a system obviously consists of hardware, software. It has people. It can take into account the processors, the storage, transmission, and even destruction of data, because processing word actually has multiple meanings. Okay. Now, this DGPMS is a system which is designed to enable processing of data. More particularly, our focus will be DPDPA protected data in a manner that DPDPA is complied with by design and default. There could be exceptions. Exceptions can be either because the law itself gives some exemptions, or because the organization makes the risk assessment and says part of the risk I am willing to absorb in the interest of better, say, profitability or whatever is that. So in such cases, the system should have enough flexibility to accommodate modifications. At the same time, recognizing the risk and making somebody accountable for the risks. And mostly, risks arising out of such exemptions should be absorbed consciously, and there has to be an appropriate documentation so that the implementing people like the DPO or his team should not be blamed for having diluted the implementation. That is why DGPSI places a lot of emphasis on getting the top management approval and creating an implementation charter supported by a deviation justification document. So when we go to the audit, we will explain it a little more. We do an audit based on an ideal situation and then present it to the management, ask the management to suggest some changes if they want. If so, with the understanding that the risks arising out of those modifications are owned by the board, we go ahead and implement whatever board wants us to implement in a, let us say, modified manner. And thereafter, of course, the risk gets absorbed, and some of which may even be insured. So this is the system of DGPMS we are talking of. Now, we must all remember that compliance is a legal mandate. It is not just a good business idea. And Indian law specifies that data fiduciaries are the trustees, and therefore they are expected to protect the interest of the data principals from the right to privacy perspective. So when we talk of compliance by design, compliance is a mandatory provision. If you don't comply as specified in the law, then you are subject to the potential liabilities under the penalty clause. Now, privacy by design, which we have heard very often in the GDPR context, is included in compliance by design because the data fiduciary is a fiduciary, is a trustee. Because he is a trustee, compliance includes a risk assessment based on privacy-related risks to the data principal, and therefore privacy by design is embedded into compliance by design. ISMS or ISO 27701 are related to the best business practices. Of course, GDPR, you may say, is law, but ISO is a best business practice. You can adopt it at your option. So if you deviate something from ISO, it can only affect your certification, but it may not affect your liability. Whereas the DGPMS is a system relevant for DPDPA compliance, and therefore, even if you deviate, you should be able to document the deviation and absorb the risk for that. Now, the creation of DGPMS, if you want a reference document, DGPSI, or the Data Governance and Protection Standard of India, could be treated as a reference document for creating DGPMS. Now, DGPMS and privacy, if you look at it, it is like the compliance is the body, whereas privacy is like the Atma. It is there. It is not omitted. Okay, though I keep on speaking about compliance, and you may also point out that DPDPA doesn't talk about privacy. In fact, if you make a search of DPDPA document, you will not find the word privacy. So one may wonder, where is privacy in our DGPMS, which is a system of compliance by design? But privacy is inherent because if you are trying to establish the role of an organization and trying to eliminate the situation where you are not a significant data fiduciary, at that time itself, you will have to make an assessment about the risks of privacy as far as the data principle is concerned. That's why I look at privacy is the soul of this DGPMS, while compliance could be considered as a body. And the most important aspect perhaps is the consent management. It is like the heart, and the governance structure is like the brain. And for all this, DGPSI is our Bhagavad Gita. Okay. Now, DPDPA compliant organization is a data fiduciary who is in harmony with privacy and compliance. That is what makes an emancipated individual to create harmony in life, and that same principle applies to the DGPMS and privacy. So, though I will be harping on compliance by design, please don't think that I am bypassing the privacy by design concept. It is there in the background. Now, if you take a step-by-step requirement of the DPDPA compliance, we can try to list some essential features of DPDPA compliance. We will go into it step by step as a part of our implementation discussion. First is we need to document the incidence of risks arising out of DPDPA. Now DPDPA is in place, a date of notification will come in, and the moment it comes in, we know exactly what is the risk and how will it affect us. For this, you need to have the identification of the DPDPA protected data, their sensitivity and classification, because sensitivity and classification will determine whether you are a significant data fiduciary or not. Volume is one criteria, but we have to go beyond volume and look at the sensitivity of personal information to determine whether an organization is a significant data fiduciary or not. We don't know whether the government will make our work easy by putting some volume limit for determining the cutoff between data fiduciary and significant data fiduciary. As of now, the indication is that the government may remain silent on that and leave it to the individual data fiduciaries to develop their own self-assessment document, which should say, I am not a significant data fiduciary because of ABC, or I am a significant data fiduciary because of ABC. So this document should be prepared right in the beginning when you make a DPDPA impact assessment and submit it to the board. And my view is that most of the responsible organizations will err on the safer side and call themselves significant data fiduciary, because most of the organizations with employees attending physical, let us say, offices and say manufacturing plants, they all use the attendance system, most of which is backed by facial recognition as well as biometrics. Now, the moment you start collecting biometrics, which is something which cannot be altered if it is compromised, you are getting into a zone of utmost sensitivity. So there are very few companies who can claim to be data fiduciaries and not significant data fiduciaries. So I feel that there will be a lot of companies, and all of them need to look at appointment of a data protection officer, conduct annual data audit, and conduct DPIA as and when it is required. So that is the importance of sensitivity and classification. Now, second essential feature of compliance is establishing the legal basis, and that is required both for the legacy data as well as the future data which will be coming into the organization. As I have already stated, making a system for the future is easier, whereas legacy data management is much more difficult. Now, next is establishing multiple systems for protecting the rights of data principles such as data access rights, correction, deletion, grievance redressal, and nomination. Then comes the establishment of a system for incident management, business continuity, and data breach notification, and then establishing systems for managing restrictions on transfer of data to data processors in India and outside. When we talk of transfer to outside, we may have to wait for the government to clarify. There will be a committee which the ministry will put up, and that committee will determine which countries are to be considered for restriction. And within the country also, there may be restrictions on certain type of data. If, for example, it may say that the transfer of data related to, say, biometrics is prohibited to be transferred to any country in the world, whereas finance data may be restricted under certain conditions. Some other data may be restricted on some other conditions. It may also say that normal demographic data is not restricted for transfer. So this kind of type of data-wise controls would be introduced in India, which will be different from the adequacy principles, perhaps, or perhaps you can say that even in adequacy principles, this kind of flexibility would be there. Then we need to apply
No,
reasonable security.
sir.
Yes, please go
Sorry,
ahead.
sir.
Yeah.
I was just
Yeah.
by setting the adequacy standards, will METI look into the reasonable safeguards or the laws prevalent in that country to protect the data while arriving at a conclusion?
You're talking of GDPR adequacy?
Yes, yes, sir. Yes, sir. Yes,
Okay.
yes.
Now, GDPR adequacy will be making an assessment of whether there is a equivalent provision for protecting the interests of the EU subjects in the respective country. But in that also, they may say that perhaps there is a flexibility. Maybe I think Mr. Ramesh will make a note of this for our next discussion. There could be a restriction which is limited to certain, you can say, categories of data fiduciaries. That is, adequacy is acceptable if you want to transfer the data to a government organization in USA, whereas to a private organization, not so. Maybe such kind of restrictions can be built into the adequacy notifications of GDPR also. Let us discuss this with Ramesh in the next session. But what I am saying here in India is that we are most likely to adopt that kind of a system, that we are not going to say XYZ country is prohibited. It will be specific to the type of data which is expected to be transferred. For example, if you are a messaging company, you are handling the normal demographic information of name, address, etc. And if you want to process it outside India, the restrictions may or may not be that stringent. Whereas if you are having a financial information, it may be restricted. So if such a system is adopted by the government, then we will be back to the requirement of classifying data on sensitivity basis. That is why, though sensitivity is not indicated in DPDPA in data classification, for certain compliance requirements, it may be necessary for us to populate the inventory of personal data along with a sensitivity score. So with that, I am trying to say that adequacy may not be total country based, but may go within that country. I think some other countries, if I remember, Canada and others have also adopted a similar approach, that adequacy by country and by type of destination data processor. Okay. I think the same system will be adopted by India. Okay.
Thank you, sir. Thank you.
Yeah. Now, the last this thing is establish systems and this reasonable security practice. That is where there is a need to introduce pseudonymization of data, then of course encryption and other things. And the rules specify about steps for data leak prevention, audit monitoring, and so on. So you need to establish compliance of that. Lastly, you need to establish systems for handling regulatory changes, which may happen, or directives given by the DPDPA to us directly. And suppose if there is a published directive to my, say, a company in the same industry, I think I need to learn from that also. So any directives published by the DPB will be of relevance for us. So we need to keep monitoring that. And of course, if penalties are imposed, then it becomes necessary to establish a system for handling the penalties, initially for asking for concessions and perhaps for voluntary, um, say, settlement, but thereafter actually attending the adjudication and say appellate discussions, appellate board discussions, and managing the penalty. and also the grievance redressal system actually is the one at which it starts with the data principle, and then the grievances management system has to expand to the DPB system, because DPB also may insist that initially that you go for a mediation and get back or something like that. So this whole system needs to be uh, properly monitored, and it can happen only if you have a system, and the DPO should seek the assistance of the legal department for that purpose. Okay. Now let us look at some practical implications of building an inventory of DPDPA protected data inventory. Okay. That is the DPD, which is the protected data inventory. Now, the first and most important thing is discovery and tagging, particularly when we are talking of the legacy data. I already have lots of data in my organization. When I say my organization, that my organization consists of data centers, cloud-based facilities, and also individual laptops of my 10,000 employees. So all these are devices in which there could be DPDPA protected data, and I need to understand where it is and what exactly I have, what are the elements I have, do I have all elements in one place? This is going to be one of the first tasks which all of us need to attend. Now, after this only you can create a personal data inventory. Without an inventory, you cannot apply the controls. Okay, so many people directly start with this, but we have a process to come to this particular stage when we discuss DGPSI. But obviously, this is an important requirement. First of all, an organization will have both personal and non-personal data. We are concerned only with the personal data inventory as far as DPDPA compliance is concerned. But if you look at ITA 2000 compliance, non-personal data also becomes essential to be protected. Now, personal data consists of data which comes under DPDPA, and sometimes it doesn't come under DPDPA, but it comes under other jurisdictional laws like the GDPR. So after bifurcating the data into personal and non-personal, personal data has to be further subdivided into DPDPA data and other data. And if you are using the same framework, you can simultaneously look at classifying the data as GDPR data, CCPA data, or Singapore data, and so on. Otherwise, you can club all those things as data outside India, that is a law which is outside the jurisdiction of India. And that is what will lead to creation of an inventory of DPDPA protected data. This is what we have to arrive at before we apply the controls. Now, as far as the future DPD coming into our organization is concerned, as long as you identify the let's say gateways through which they enter, like the website or an application or something like that, then you can ensure that you can implement compliance at the entry gate. Okay. Whereas existing data is already scattered across various places, some of which is unstructured form. Therefore, it is difficult to discover and identify. As far as I know, though there are many data discovery tools, I am not sure whether they can effectively identify personal data to which DPDPA will be applicable. Now, using available tools without extensive customization could lead to mistagging. So one has to be very careful in using the existing tools or try to develop a system of your own. In fact, DGPSI tries to take the approach where we use a semi-automated approach with more of involvement of the internal people to actually discover DPD within an organization. Then the next question when we identify this is, how do we identify the DPD in this vast data store we have. So we actually try to have an approach which is called a process-oriented approach for compliance. And we identify a process owner and we make the process owner take the responsibility for creating process-wise data inventory. And later on, we aggregate it and create a enterprise level data inventory. We will think about it a little more to understand what is the advantage of this. Because if you use an automated software and just ask it to search through the entire database, first of all, you have to actually put up such queries which are given to the software so that it identifies the personal data properly. Otherwise, there will be some false positives, false negatives. So there is a need to build the inventory with some kind of a human oversight. So what we are suggesting is you need to have a process whereby you need to identify data elements, personal data elements that are floating around in the company. Okay, when I say data elements, I am talking of orphaned data elements like an IP address comes from some system, some name comes from some other system, some email address comes from some other system. So these are all the data elements which are within the custody of an organization, but unless they are organized together, you do not know whether it is personal data or not. So from this, you have to identify the relationships between multiple data elements to recognize whether multiple data elements refer to a single individual, and when they actually come to represent a single individual, it is like the nucleus, and surrounding the nucleus you have got the electrons. You have to then identify the particular data as personal data. There is a critical level where a core data will have to be there to identify a particular set of data. That core data can be something like the PAN card, something like the Aadhaar. Name alone is not likely to be considered as a core data, but in the employment situation, sometimes your employee ID can be considered as the core data element, which alone can be a most important identifier for the personal data. Similarly, in a hospital, the patient ID may be a very important core ID. That ID, you actually associate a name, associate one or more email addresses, you associate a mobile. These and also the reports generated like the health report, financial report, bank account number, and so on. So around the core ID, which is the nucleus, you accumulate the other data elements, all of which are today floating around in the organization, and you need to actually bring them together. And then you have to also look at, say, deduplication and other technologies so that you will be able to filter that and call that as a personal data inventory. Okay, because in these binaries, you have to pick out a name, an email address, mobile, whatever is that. So ultimately, what exists in the company is binaries. There you have to run some software to identify whether this set of binaries represent an address, PAN number, and Aadhaar number. Then you will be able to identify the personal data. Therefore, you need to first create a personal data lake for identifiers first, and then apply data analytics, and then come to personal data store. And then within this personal data store, you may have to associate the data subsets of data elements to multiple or different processes, because process 1 may require a few elements, process 2 may require a different element. So this is what is going to be a challenge, because we cannot look at the data discovery software to be run through this. And in fact, we are trying to undertake a development of a process under this AI chair, where we may have a system which can create this kind of human oversight and automation together. Behind this is the concept that DGPSI suggests compliance by design as a process-based approach. That is, enterprise is treated as an aggregation of processes, and application of compliance is done at each process level. Your concepts of data minimization, data retention minimization, reasonable security, access management, storage security, all are controlled at the process level. So by doing this, I am actually trying to reduce the complications, because an organization has got multiple processes, the requirements of processes are different. So instead of having a common system, I am trying to identify each individual process as a different subunit and apply compliance there. An example is that an organization will have a website. Now, personal data processed on the website is one process. The organization may have an email system. Personal data processed there is a different process. You have got set of employees. Personal data of employees is a separate process. You can call it as HR process or whatever is that. You may have retail stores where customers' personal data is collected. If the retail store belongs to the company, then you are responsible for that personal data. Sometimes retail stores are owned by franchisees and others. And we discussed last time about the concept of super data fiduciary. So how you share the responsibilities between the main brand owner and the others will also have to be taken into account. If you have got an e-commerce website, obviously there is going to be a lot of e-commerce customers coming in. This is a different process. Then if you are using AI in some way, the algorithm itself is a process. I think the sharing went off. I don't know why. Are you able to see it?
No, we are able to see.
You are able to see the
Yeah.
Okay. It
No
went
issues.
off. Yeah, okay. Yeah. So the AI algorithm itself is a different process. So there may be a number of such processes. It may not be just 5 or 6 in an organization. And if you want to break it up further, you can break it up further. My thought process is that if you bifurcate the organization into the multiple processes, then you can apply different controls. Even today, of course, right now we are talking of even collection of personal information. Now, collection of personal information for e-commerce customers is different from collection of information for employees. So each process has got its own requirements. And when you talk of a data set, let us say you are having an inventory where you have got a particular customer ID in a centralized database of personal data. You have got one customer, you have given him a particular ID, and against that particular name, you have got the various data elements. Now, some of those data elements are relevant for e-commerce process. Some of them are relevant for some other process. So we can actually create subgroups of these data elements and link it to the specific process that will take care of the data minimization requirement. And when you segregate the data elements within a data set, you will also be able to apply data retention minimization specific to those 2 or 3 things. For example, you can remove the address only if you don't require the physical address. Okay, that is data retention of address is not required beyond a particular process where there was something required to be sent to his physical address, like an e-commerce company sending an article through the logistics company. At that time, physical address was required. Now, once that process is over, you don't require to hold the address. So the data retention minimization, data collection minimization can all be linked to the process requirement, and there will be a process owner who can actually guide you in that. That is the process-based approach of DGPSI. We will discuss if you have more questions on this, but the organization will be a combination of process 1, 2, 3, and this also takes into account the other problem which we looked at, that we may do certain processes in which I determine the means and let us say the purpose. So I am the data fiduciary. In certain processes, I am a significant data fiduciary because I process a particular sensitive information. There are certain other processes where I am only a processor. Somebody else gives me the information, I process it and give it. So there could be this process-wise, say, a determination of the role of the organization. And the organization, obviously, if you want to err on the safer side, you have to adopt significant data fiduciary. But within that, if you want to allocate priorities for compliance, you can look at this process-wise bifurcation of the organization as facilitating prioritization of your resources, and you can call your organization as a hybrid entity where I am a data processor, I am a data fiduciary, in some cases I am also a significant data fiduciary. Because of this, in our approach of arriving at the personal data inventory, we say that first you have to identify the process inventory. First of all, any organization has to determine which are all the processes in my organization where personal data is being processed. Now, this is easier than identifying the personal data itself, because at personal data level, you have to go into the individual data. Here you are going to the identification of organizational activities. Most likely there will be a department for each of these processes. There will be a department head. So making a process inventory is easier, and then ask that process owner to actually develop an inventory of personal data being processed by him, and later on take it and aggregate it is a better way of doing things, is one of our views. So because of that, we say you need to create a process inventory which will have a unique process ID. It will identify the input and output. It will have a name, therefore it will have a process description. Each process has got a purpose. So the basic theme in this process bifurcation is one process for one purpose. So for a given purpose, I identify a process. For that, there has to be some input. For that, there will be some output. There will be a process owner, and I will take care of the notice and consent related to the input data elements. There will be a separate storage associated with it, retention. The access controls will also be determined based on the process requirements, disclosure requirements. All this is part of this process inventory until this data output is pushed on to the next process, where in the next process, this will become an input. By creating such an approach, I feel that your creation of the personal data inventory is made much more feasible. Okay. Now, at this point of time, let us have some discussions on this concept of creating a personal data inventory through creating the process inventories. Yeah, I think Deepthi has got some question.
Sir, coming back to the before two slides that you were discussing on classifying of hybrid model of significant data fiduciary and normal data fiduciary.
Yeah.
So basically, any entity will go by the definition of what, say, DPDPA prescribes. If we break it down, they might not buy that definition that, okay, we are not significant here and we are significant here. I mean, from the nature of classification, if they are handling a volume of data or a sensitive like a biometric data, then they are automatically significant data fiduciaries. If we look at what I understand from here is that if we are looking at a processing entity like the banks or the healthcare departments outsource their processing of data, that particular entity can be termed as a hybrid, if my understanding is right, if we do the audit of that particular entity.
See, as far as the law is concerned, law is deficient to the extent that it does not identify this kind of, you can say, virtualization of different processes and identifying the roles for each process. The law only talks about an organization, data fiduciary can be considered a significant data fiduciary based on the volume and sensitivity, the risks to the data principle, risk to the electoral democracy, and so on. Some 5-6 items are there. All that refers to the organization. So in the law, there is only one category that an organization can be a significant data fiduciary or not. Agreed? I accept that. Now, what I'm saying is when you come to the implementation of an organization, if it is possible for you to identify processes in which risks are less, processes in which risks are more, and processes in which you are not a data fiduciary at all because you have got certain capabilities. Let us say somebody wants you to give some service and you accept that as a divisional, outsourced, say, business and act only as a data processor. Okay, like a bank now, a bank also does some insurance marketing. Now, insurance is the business of the subsidiary of the insurance company. But they ask the bank that, why don't you help me in, let us say, marketing my insurance thing. There, you may be actually processing the data on behalf of the data fiduciary, which is the insurance company. Now, that may be a division. There is a person in charge of the division. So what I'm suggesting is, why don't you look at prioritizing your compliance requirements different from your banking activity, core banking activity, where the DPO has to sit on a day-to-day basis, and these customer service aspects, which normally are less risky, and there you can ask somebody else to take care of. So that kind of process-wise division may help in the implementation. As of now, law does not recognize this distinction, I agree, and that cannot be changed now because law has already been passed. Okay, it would have been better if Ministry of Information Technology had taken note of some of these things which I have been talking about for quite some time. Again, it is a very, you can say, revolutionary thing because nowhere else in GDPR or anywhere else that system has been recognized. But now at the time of implementation, if I am a CEO, I have got 10 departments, I have to allocate my resources, which is scarce, to all these 10 divisions. I need to have a kind of prioritization. I am looking at this as a method of prioritizing that. Is it okay?
Right, sir. Understood. I mean, there are cases like you gave the example of insurance,
Yeah.
where a third party insurance is being sourced as a product, but the ultimate decision making authority is that particular product, the insurance party who's tied up with.
Yeah.
And there is no processing being done by the bank. But if we go by breaking up the definition of significant data fiduciary, the volume may be high, but not the ultimate means and purpose of the data is not classified under that particular process of
Yeah.
that.
All this has to be backed up by your policy documents. Say tomorrow, if the DPB asks you, oh, why your DPO is not visiting this division daily as he is supposed to do, or he is not looking at the log records of this department. He is looking at the log records of another department, but this he is not doing it. You should be able to explain that in our prioritization, we have considered the following priority. So therefore, he looks at more critical core activities as his first priority and then others. So this kind of documentation, if you prepare, I think the DPP also will understand that. See, otherwise there is no way one DPO, for example, in a bank, will be able to attend to the requirements in all the divisions. Tell me who is a superhuman who can do that. Okay, there are so many activities which are happening, and unless you build, what we are suggesting is each process owner is a sub DPO. So in his process, he knows more about it and he knows where are the risks. He can actually find out what are the pain points and find out. Whereas the main DPO may not have that much of say visibility. So this kind of an approach, process-based approach, is better. Ramesh, you have got something to say?
I think a point taken that only Deepti, the question is, the concern is, what is the starting point? Enterprise level, right? We all know everybody is struggling and everybody is collecting tons of data. Now, what is the starting point? And as you correctly mentioned, some places it may not be relevant. That's where I'm sure the data protection impact assessment or the risk assessment is going to help you and me that where I need to concentrate. That's where the tagging going to help you and me. Is it a DPDPA data? What Naavi are talking about DPD, right? So like that, I think in multiple discussions, I remember last year with the CIO club when we proposed this process. Organization is an aggregation of the process and data discovery and data inventory to be done at the process level. Now, obviously, which are all the processes? So we need to have a critical process in mind to start with, and then I think it will follow. Otherwise, this question is always going to be hindering us that where to start and what should be the criteria and so on. And especially Naavi sir, again, the problem here is with the significant data fiduciary volume. I understand you mentioned so much in our discussion this morning. But what about sensitivity? We do not have a proper definition yet, like GDPR, correct? Now,
No,
I'm
it's
assuming.
okay. No, when there is no definition, it means
It's in
that
my interpretation, financial
your
data or health data. That's all. So
that's
it may not be. So I'm assuming that DPD Data Protection Board might also give you and me the clarification on the definition of the sensitive data like GDPR. Then it will also be interesting.
What GDPR has given is only something like racial data.
Correct.
We also
Correct.
had that in the ITA 2000. Okay. In fact, it was not, you can say, completely useful also. Okay. Now, there may be, if you will considering if there's a data field where I say I am a male or something like that, you consider that as the most sensitive to be protected. Mr. or Mrs. is the most sensitive. But in practice, that is not necessarily the greatest of the secure information. So the earlier approach to sensitivity was based on other considerations. But now what the government says is, you are the data fiduciary, you determine what is sensitive, what is not sensitive, give a sensitivity score. In fact, our data inventory, we will suggest a data, sensitivity score. Though it is not there, we are giving it there because that will determine what kind of risk management tools you have to implement. Should you have encryption? You may have encryption for something which is considered sensitive. If something is not considered sensitive, you may bypass that. Okay. So these administrative decisions can be taken based on the sensitivity score. So I do agree that you have to take a sensitivity score, but what is this criteria for determining the sensitivity? Not that it is gender, it is not, it is sex or something like that. It is the risk of harm to the data principle. If you think that somebody being a female is a risk, you have to justify, is it a risk which needs to make it sensitive or not? So risk to the data principle should determine the sensitivity, not that it is a particular kind of data such as related to gender, related to something like that. So
We
that
can go from
flexibility is
the
available.
harm tomorrow if there is a breach. What kind of harm or the monument of harm that we are looking at? From that, we can reverse engineer back to understanding
Correct.
what is the level
Correct.
of
Correct. See,
sensitivity, what kind of
there,
sensitivity is.
there itself, for example, this gender revelation of a gender, it may differ from data principle to data principle. A city-bred lady may not worry too much if somebody knows that this netizen person is a lady, whereas a more sensitive village person in Salem or something, their sensitivity of gender may be of greater significance. This kind of say micro level management of sensitivity is possible if you don't tie yourself up to the sensitivity definition based on password is sensitive, information is sensitive, or some say health information is sensitive. Within health information, there may be a blood group which is put on a card. I may be putting it in my pocket because if there is an accident, I want everybody to know what is my blood group. Now, the sensitivity of blood group may be different from sensitivity of, let us say, my heart condition or something like that, or whether I have, say, a communicable disease and other things. So there is a possibility that sensitivity scoring may go beyond the type of data, but go into what kind of harm it may cause to the individual. So that flexibility now is available with us, and we can try to use it. So I'm not saying sensitivity is not important. It is important. It is important at the time of even determining whether I'm a significant data fiduciary or not. Therefore, it is part of the compliance framework, but in a different way. Okay.
Naavi sir, another important thing I see is like I think we go through the general like in categorization, right? Oh, this is sensitive, this is not sensitive for a race, ethnicity, and all. But recently I was reading through this issue, like Scotland police, right? They published a list of criminals in the local paper or something like that, right? And
Yeah.
yes, the same name, that name, then the context actually becomes sensitivity, like my image is there.
Agreed.
Oh, it's a good
Agreed.
digital response. Oh, wow. My family
Yeah.
members will not like it.
Yeah.
This is like a member of parliament. It's good. So in the what context you are going to put it, then the sensitivity is also going to be accompanying with that, context. That's what I know. I think we somehow fail to address that in most of the cases, I feel.
Yeah.
So with the traditional approach, we take it with GDPR, some examples, I feel.
Yeah.
Mm.
Yeah, say GDPR is all said and done 7 years old. No, we are now wiser by 7 years, so we should actually have something more. Okay, so I feel that sensitivity should be related to the harm caused to that particular data principle as per definition, and that sensitivity score can be attached to the uh, personal data inventory as a tag, and based on that, controls can be different.
Even
Okay.
simple name can be, but, become sensitive. It
Yes.
can be more sensitive, like, in what context we are referring to that. When based on those, traditional, some lists they are given in the sensitive information, right? Like in
Agreed. Agreed.
PDPA, GDPR. So it can again take a different, context. So, yeah.
Agreed. Agreed. You are perfectly right, and I agree with you. Fine. Now, Das Gupta has got something to say.
Sir, I just was thinking, is the concept of sensitivity is basically a dynamic concept. What may be sensitive today may not be sensitive tomorrow.
Okay.
So it's an ever-changing thing.
No, it will change, and it is related to the person. Now, you ask me whether my mobile number is sensitive to me. I cannot say it is sensitive because without my mobile number, I cannot do my business. So I am putting it on my website. Okay. Whereas somebody else who does not need to deal with the public so frequently, for him, mobile information may be considered as sensitive. So it all depends upon the context and the person.
Yes, absolutely.
Okay.
I just wanted to clarify. Thank you, sir.
Okay. Now that provision, I'm trying to invoke and say that it is possible to do that in the inventory classification itself, with the data inventory, and then use it appropriately where it is required when you want to give controls. Okay, fine. Anything else before we go to risk assessment? Now,
Naavi sir, sorry to interrupt you.
yeah,
Are
please.
you following the same thing like in GDPR and USA, right? US and European Union, they follow the DPDPA and PIA. And are you also using this just privacy assessment after that we do it? I'm not gone through this legislation, sir. I mean this like impact analysis we do, right? Assessment we do, right? Before that, are you doing the privacy assessment also? That kind of thing is there in this legislation, sir? This instrument?
This
I'm not gone
legislation,
through. That's why I'm asking.
no, this legislation doesn't go into the detailing of what you should do today, what you should do tomorrow. Okay. Now, when you are a significant data fiduciary, it says you have to do something called DPIA. Now, when do you do DPIA? At various points of time. In
Right.
fact, if you are today not DPDPA compliant, because DPDPA was not there until today. Okay. Now, tomorrow DPDPA comes. That is a significant change of risk profile for an organization, and you have to do a business impact assessment. Okay, you call it as DPIA at one level, doesn't matter. You are processing data, and that is going to have some impact. So you have to do an assessment. Now, we use this PIA or privacy impact assessment at one gross level, that see, organization has to first understand what will be the impact on that on my organizational risks. Then I ask my CISO or my DPO, please go into the details of our processes and identify the risks from the gap analysis point of view. So you may, if you want, you can make a distinction of this impact assessment as the board level assessment of how the act will change their functioning, whereas you can consider DPIA or data audit as, or gap analysis as more, you can say, lower level, kind of lower in the sense that deeper level of, say, assessment. Okay. Otherwise, the Act doesn't specify that you should do a privacy impact assessment. It is, when you say you are a data fiduciary, government says, why I should tell you, you should do it. Okay. So you see the advantage, or whether it was done deliberately or not, I don't know. But now I am imputing that it was a very clever way.
So comprehension skills are supposed to be, like critical here. If somebody is not able to comprehend that, any code, and it's going to be difficult. We're going to land in that,
That is where the role of consultants is better.
That's where FDPA comes, sir.
FDPA comes in, and the data auditor's role comes in.
Yeah.
And external consultant to be appointed to help the local DPO, all that becomes relevant because, see, not that I possess certain knowledge which nobody else does or something like that. I might have spent more time on a particular thing, so I'm actually saying more things. You may, as a company official, may not have so much of time to debate on these things because you are more concerned with the day-to-day customer-related problems. So therefore, there will be some difference in perceptions, which you have to bridge by ensuring that you have adequate assistance from external sources. That is the thought I would like the corporates to take into account. Okay, fine. Now, going into the risks, I look at actually three kinds of risks. One is the privacy risk, which will be risk of missing out on any obligations which the law wants you to do for privacy protection. Second is the security risk, which is compromise of CIA, but we are talking of CIA of personal data. CIA of total data, you are anyway trying to do under your ISMS systems. You are already certified sometimes of our ISO. So you are already looking at CIA from one perspective, but we are now looking at CIA of personal data, provided you have an inventory of personal data, which is coming under this DPDPA. Once you have that, then security of that comes under the CIA principle, which for which you can use the ISO type of say approach. The last one, of course, in the risk is personal data destruction or modification or exfiltration also becomes important to see as a part of the DPDPA risk. It's not only privacy risks such as not obtaining the consent or something like that. It is measures to be taken to prevent exfiltration is also part of the DPDPA risk. Now, we have actually tried to make some kind of a list of risks. Let me come to that. But the objective of risk assessment is to understand the DPDPA impact on the business organization. That is where you raise this point. Is our company impacted by DPDPA? That is the privacy impact assessment. Next is significant data fiduciary identification. Then come to data protection impact assessment based on a chosen processing instance. Then we need to actually make a risk assessment from the point of view of a suspected data breach. And then, of course, annually, you are expected to make some kind of an assessment. Now, once you have a risk assessment, then you need to make an assessment, which is the gap. Then you mitigate, then you reassess, and then you correct, and then, if necessary, insure. The gap assessment comes under the first assessment. Then we have the implementation to mitigate. Then reassessment, you can look at the maturity of implementation. We have this data trust score system for that. Then if you need to correct, then at that time, the audit becomes important. Then after all these things, if there is a residual risk, you need to actually have some kind of a cyber insurance. So these are the actions which have to follow the risk assessment. Yes, the risk itself can be monetary loss, reputation loss, business loss. Because some of the data losses can invoke ITA 2000, there could be even risk of imprisonment of executives. This is not a risk arising from DPDPA. It is a risk arising from the link between DPDPA and the ITA 2000, which automatically gets invoked because your data principal who files first a complaint with the Data Protection Board will also go to an adjudicator because his personal remedy, if he wants to seek, he has to go to the ITA 2000. The moment he goes to ITA 2000, he says that there is a section 43 violation. Therefore, I need to be compensated. The moment that section 43 violation is recognized under Information Technology Act, it automatically invokes section 66, which is a cognizable offense. So it does look at the possibility of criminal consequences of what otherwise would have been a simple, violation of DPDPB. Okay. Then business continuity, liquidation of the company itself if the penalty is too huge, employee disgruntlement. These are all the consequences of DPDPA risk manifestation. Okay. Now, this, I think I already spoke about this. DPDPA does not segregate data, but sensitivity is required for significant data fiduciary, and therefore you have to take it into account. Now, coming to this risk list, we have identified some time back a list of around, I think, 50 risks, which you can use for creating a risk register. I will just read out a few just to give you an idea of how we are looking at the risks. For example, personal data collected or processed for unlawful purpose is a risk. Now, do we as a company do it? We are not supposed to do it. But is it possible that any of my employee anywhere else in any of my branch has been processing data without my knowledge, which is not strictly legal? That is what you have to identify it as a risk. And then if there is no such risk, we are all happy. Then, because the first thing in DPDPA is that no data shall be processed for purposes which are not lawful. So that's why this is first risk. Then personal data is collected or processed without a consent or without a legitimate use. So that is the legal basis not being present. Then personal data being mistaken as voluntarily given or publicly made available when it is not so. because these are exemption clauses in the DPDPA. It will be very convenient for our field level people to say it was voluntarily given. But if you don't have proper documentation, then that may be questioned. The data principal may go back and say, I did not give it voluntarily. This person insisted that I have to give, without which service will not be given. Therefore, I gave. Like the example of Aadhaar being collected by hotels, when they can as well take a senior citizen card or some other card as an identity of the person. But the counter clerk insists that I need only Aadhaar. And then after I have given, if there is a DPB inquiry, the hotel may say that we just asked for identity, this person took out and gave the Aadhaar. So there can be a situation where you are claiming that it is voluntarily given, data principal may not think so, and that could be one of the risks. Status of the organization misidentified. While you are a SDF, you identify yourself as a DF, that itself is a risk. Okay, status of an organization as data fiduciary is misidentified as a data processor. Status of the organization misidentified as exempted category. I am an instrumentality of the government. I am an educational institution, let us say, or even an organization like AIMS. AIMS is perhaps somebody who can claim I am an instrumentality of the state and therefore have certain exemptions. IITs, IISC, or some such organizations may claim that I am an educational institution governed by certain separate statute, therefore I am an instrumentality of the state. Now, have you gone through the details of what is the instrumentality of the state under Article 12? Have you gone through the legal cases? And are you sure that you are instrumentality of the state and available for exemptions? Otherwise, that could be a risk. Okay. So that is the kind of risk statements which we are trying to do. Now, consent is supposed to be authenticated. Now, I cannot get digitally signed consent. I just take a click wrap consent, which may not have legal, validity. Is that a risk? Yes, it is a risk. Inability to provide purpose-based notice in 22 languages. I want to simplify my work. I have got 10 different processors. Naavi suggests you need 10 different privacy notices, each in 22 languages. People will say, why I need to create 220 documents? Okay, so I will give one document. It will contain 10 different purposes, and I will give it in English. And at best, I will give you one local language kind of a thing. That's the risk which you are taking. I am, as an auditor, saying that you should give 22 consents, privacy notices, one for each purpose. And then each should be available in 22 languages, because you may be located in Bangalore, but you may be not aware of Kannada, you want Tamil. So the law says that you should give that option to the particular person. So that is a risk. Okay. Then inability to store the consent and retrieve. See, all consents need to be sequentially numbered. It has to be stored, and at some point of time, you may have to retrieve. Now, if you cannot do that, that is a risk. So in your risk register, these are the things which you have to come. Inability to identify the expiry of the purpose of minimal data requirements. So you have retention deadline, you have to give after what time it is no longer required. Same thing comes in the case of minors. You have to say that the parental consent is available only up to a particular point of time, 18 years. On or after that day, parental consent has got zero value. Now, if you are not able to identify that, that is a risk. Now, first of all, you have to identify, is this a risk? And then you ask your technology person or a departmental person to find out what you can do about it. Okay. So like this, we have identified multiple things. Inability to accept instructions from the consent manager. Now, you have not made provision for accepting information from a consent manager. Somebody registers himself as a consent manager and he wants to actually send a consent for one of his clients. and you say, no, my system is not ready. Okay, like when Aadhaar introduced this virtual Aadhaar, every organization collecting Aadhaar was supposed to make it possible for them to receive that 16-digit number instead of the 12-digit Aadhaar number. But I don't think that many of the organizations, however big they are, made provision for that. They just ignored the instructions. Now, today, the same thing they may do. They may ignore the need to have consent managers consent. And if so, that is a risk. Yeah, Subraidu.
Yeah, yes, sir. The previous slide, point number 8, you were saying, I understand your point that quick wrap kind of a thing might not be recognized and all. Are there any specific contexts which is mandatory? Is it in every case where consent is?
See,
The banking, healthcare, I can understand you might have a
okay,
proper consent which is legally enforceable or something. But
okay.
let us say you're going to the website of a company and for cookie acceptance also generally we give a preference, right? Now, is that also required? Does that also require a higher level of consent? The way you're
Say, consent should be like a contract. Agreed? A contract requires a acceptance, and electronic documents can be authenticated only by the use of electronic signature as per ITA 2000. These are all the given legal situations in India. Now, suppose you want to bypass this, what it means is that you are accepting a certain level of risk. Now, if you feel that that risk is manageable, please state so. You may say that I am going to take this, I accept or something like that as a valid contract. I am aware of this risk. So in the policy document, you have to say this has got the risk. Okay, that it is not a recognized form of authentication under ITA 2000. However, the organization accepts this as a risk because for violating this, what will happen? The person is going to actually claim tomorrow that I have not given the consent. Okay. Now, I may be actually trying to build certain metadata and other things and have some kind of a certified collection of the consent. We have a system. In earlier these things I have discussed that also. Okay. Based on this section 63 of Indian Evidence Act, Bharatiya Sakshi Adhiniyam, you can create an admissible evidence out of a click wrap contract. I may do that and say that I will adopt this. So, but still in the court, somebody may argue that you should have used a digital signature. Then that little risk difference I will have to manage. So this has to be understood, flagged, and then put into the document. We cannot be ignorant of this, but otherwise it's okay. Okay. Yeah.
So,
this 50 risks itself actually covers the entire DPDPA, and we can take 5 days. Yeah, Mahesh Prasad has got something. Yeah. Mahesh.
My voice is clear? Is my voice clear?
Mahesh, you have got any questions? No? Okay.
No, your voice is not clear.
My voice is not clear?
No,
Okay.
Mahesh is
Mahesh,
the
okay,
person
okay.
who's trying to ask.
Okay, his system is, I think, was disturbed. Okay. So I say each of these 50 actually addresses some provision of DPDPA. When I give you this presentation, you can go through it once again and then raise any specific questions. For example, inability to provide data access rights. When do you fail to give data access rights? Somebody writes to you in an email that I want this information. You are not able to identify whether he is your customer or not, whether you have his consent form collected 6 months back or not. That is the inability to provide data access rights. So like this, every section of DPDPA has been analyzed and we have tried to create this risk register. You can convert this appropriately to your format. Okay. So inability to accept nomination, inability to identify the death of a data principal after he has given a nomination, inability to identify the nominee, inability to resolve the dispute between legal heirs and the nominee. These are all the risks which we need to factor in which you have not looked at in the ISMS scenario. So these are all something which is new, and some of these things on nomination is only available in Indian law, and it is, even if you are GDPR compliant, you would not have made this into your risk statements. So you need to create a new risk register exclusively for DPDPA. Okay, fine. Then I think I will proceed further. There are about 56 risk statements which we have put here. This is also available in the DGPSI booklet, so you please look at that. Okay. Now, with this, you can create a risk register. You can give a risk ID and description, classification, risk owner, probability, risk score, treatment plan. All these things you can prepare. If this is the format which you are comfortable with, you can do that. And again, when you are talking of risk owner, because under DGPSA, we say process owner is the person in charge of the particular process, he automatically becomes the risk owner, which means that as a DPO, you may have a difficulty in understanding the risk, whereas a process owner has got better understanding, so it will be more efficient. Okay, so DPO should create a note on each of these risks. Okay, I will try to go through the next few slides reasonably quickly so that we will have time for the next session. Now, as far as the security risks are concerned, you are all very well aware of the CIA principle. Therefore, you can look at adopting the ISO 27001 principles for the purpose of accepting the risk of CIA compromise as one of the risks. But I'm here again focusing more on the DPD only. Rest of the things will come under ITA 2000 compliance. Now, as far as loss of data is concerned, you must have a mechanism to monitor exfiltration of data. What is the extent of bytes which is going out of my network? If you don't have a control on that, you will not know how terabytes of data have reached the dark web. I don't know. I'm not a manager of a network. Most of the data managers say, no, it's not possible. But I don't see how it is not possible. When your average some data which is going out of your network for disclosures and other things is, say, 1 TB, and suddenly some days it goes to 3 TB, then you must know there is something wrong. Okay, so unless you have a system of monitoring, it is part of the log monitoring actually. Monitor the number of bytes of data which is being exfiltrated out of the network. All this, of course, becomes easy if you are having a centralized database. If you are having multiple databases in multiple physical locations, to that extent, it will be difficult. But again, coming back to the process level management, if I am the owner of a process and I am putting the data under my own storage, suddenly I see, and I have to suppose give the output to another process. Now I know exactly that how much of data has to go from my process to the next process. It has got certain finite averaging. And suddenly, if it is more than that, if it is going out of my system, then I know that I have to flag that kind of a thing. This is what monitoring of log records should do. Then if data is found on the dark web, definitely it is a risk which has to be flagged. And if exfiltrated data includes biometrics, remember it is not recoverable. Risk of misuse, impersonation will all be there. Okay. For mitigation of risk, of course, we will discuss the frameworks. DGPSI Lite will cover most of the risk. DGPSI Full could cover almost all the risks. And before we end, I will just go through this data classification, which is another prerequisite of the compliance, where we have a lot of difference between the current way people handle it. Now, the objective of data classification is, one, to determine the applicability. For example, non-personal data and personal data, it determines the applicability classification, classification for applicability. Then application of different kinds of compliance controls, you need different classifications. we feel that if data is classified as per compliance requirement, then compliance will become a breeze. Okay, that becomes easy. If you know how to classify, then implementing controls will be easy. Okay. Now, existing data discovery, classification, consent management tools, I would like each one of you to check whether they are capable of identifying which data is DPD and whether they can classify the data as required, and whether it can help you in data retention minimization, whether it can identify unstructured DPD. Before you actually appreciate DGPSI, you need to think about all these things. Now, if you look at ISMS, that you already have a certain classification, but that approach is basically public, confidential, secret, or something like that, because this is aimed at the CIA principle. So similarly, other frameworks may have specific ways of classification based on that particular framework. But classification under DPDPA, you have to look at what this act requires. CIA is required, it is necessary but not sufficient. But classification has to match the DPDPA requirements, which is already captured in the risk list, which I mentioned. Now, in terms of classification, I have observed that there are about 31 types of classifications which are essential for DPDPA compliance and which is all comprehensive. That is, if you bifurcate your data into 31 types, then you can apply 31 types of controls to each of these, then your compliance is done. If at all there is going to be an automated solution, that automated solution will fit in only after this proper classification has happened. And we are going to try to develop that. I have already made an announcement today that it is the project 2 of this AI chair. Project 1 of AI chair was the impact of AI on children. Okay, that is one project which we want to take. And second project which we want to take is development of the automated tool. Okay, Mr. Dasgupta.
Sir, while talking about classification, I was wondering, classification is also essential for optimization of the resources, because if we classify based on criticality, we can allocate the resources in a much smarter way. Otherwise, because otherwise what will happen if we put the same level of controls to everything, there will be a wastage of resources. So I was just wanting to hear from you. Your
Perfect. See, that is why DGPSI is a system which is developed from, you can say, practicing professionals. We are trying to understand this requirement and trying to put it as a framework. Okay. Now, when I say 31, people will say, why so many classifications? Okay. Why not have 2, 3 classifications or maximum 5? But this 31 classifications will make your subsequent step of compliance easy. For example, the first classification at the top level is data that is not identifiable with any individual. That is what I call as non-personal data. I will put it aside. If necessary, I will apply ITA 2000. Otherwise, I am not bothered as a DPO as far as that is concerned. Now, data set which is identifiable with an individual is the personal data. Now, within that, there may be other classifications. For example, personal data which is belonging to more than one data principal. Can there be such things? When there's a group data, now how do you handle that group data? Do you require consent from all the members of the group? These are issues which you have to tackle. Okay. Now, personal data, which is also the business data of the data fiduciary. This is the transaction data. Okay, including metadata. Now, metadata or transaction data partially belongs to me, the data fiduciary, and partially belongs to you because your name is there, whether it's invoice or something like that. Now, this is for me a classification. Now, what kind of controls is required, we will debate later on, but it is required to have this classification. Personal data to which DPDPA is applicable under section 3A1, which is collected in digital form directly. Next is collected in non-digital form and then digitized. So suppose I have got such data, I would like to give it classification tag that this was collected first in non-digital form and then digitized. Then personal data to which DPDPA is applicable for processed outside India related to provision of services to data principles in India. So again, the applicability class. So each of these classification address a specific compliance requirement of DPDPA. And when you do this, you will be having an inventory of personal data to which one column will be classification, and that classification will directly determine what kind of controls are required. You need to have a minimum of say 31 controls, maybe one or two, maybe combined, and it may be actual less than 31, but still you can identify that the number of controls is somewhere, let us say 25 to 30, and that will be sufficient for you to manage the compliance. For example, personal data of a minor. Now I need to classify it separately. Personal data of a disabled person, I have to classify that. Personal data of a parent, I have to classify differently. Same person can be an individual. He may also be a parent. He may be a parent of one son. He may be a parent of one daughter. Now, there could be differences. And depending upon the age of the son or the daughter, this data of the parent may change its status. So I need to identify this and classify it properly. Then only I will be able to apply the compliance. So personal data of the guardian, then depending upon the exemptions, different types of data, that is personal data of an entity which is going in for merger, personal data of a startup which has been notified, personal data being processed by a data processor under GDPR. These are all the categories which come under DPDPA. So while we read DPDPA section by section, each section we have identified as a class of data, and that is what we have tried to identify as a classification. Once you have this classification, then tomorrow we will discuss about controls. Okay, so any questions before we break?
So last mark at the side.
Yeah.
So there was two sections there where one collected through digitized and one collected manually and then digitized. So of course the section gives the section has been labeled with a different numbers. So in terms of classification, how is it going to be different? At the end of the day,
Now,
if I'm collecting an Aadhaar number.
Where do you get the consent for category 1, which is collected digitally? You directly collect it at the collection form. What about manual? Where do you collect the consent? And consent you might have collected in paper form. You might have you converted it? Where is it stored? Have you put up only a notice or something in the visitors, this thing that your first is being collected? So there could be some differences between the two. If there is no difference, you can still, controls may be combined, but there could be subtle differences.
Okay. I understand. Can that not be handled through processes? I mean, say when you collect the data and the digitized.
There will be a process which is different for each of these
sections.
Purposes, no.
Correct.
If you define the purpose as processing of data collected manually and then digitized, then you look at what controls are required for that. So this classification is linked to even this process-based approach. They're all interrelated. Okay.
So what we do is, just an experience. So we have the metadata, which is the technical metadata where I have a table, column and all. That's where we classify whether it is a personal data, sensitive personal data, or a basic personal data, and align that to the business metadata. So for example, if it is a first name, middle name, last name of me and my parents and my children and my guardians, these are being identified with the business glossary, which is attached to the specific table and the column, but the classification remains the same, like it is a personal data or a sensitive personal data, as the case may be. Say, for example, Aadhaar number of my parent versus Aadhaar number of me, the classifications remain the same, only the glossary identifies whose data it is. Again, it is just the way we classify it is the experience that I am sharing here.
No, that's fine. That's fine. Yeah. So the objective of this session is to bring in some discussions on GDPR and ISO 27001, which we are not otherwise having
Just a minute.
a detailed discussion. Before we go further, Mahesh says in questions, do we have any checklist to determine if our organization significant data fiduciary or not? Then consent manager. Okay, we'll discuss about consent manager if necessary tomorrow. Okay. Then as far as the significant data fiduciary, I think in our risk register, we have added a few questions that you can take as the indicators of what you need to look. Okay. So coming back to this session, the objective of this session is to bring in the knowledge of GDPR and ISO 27001 to this discussion. In fact, when we handled the offline courses, we also discussed alternate frameworks like DSCI, but this time we may not do that. We'll see if necessary. We'll take care of that in the next week. So now, all of us, more than me, all of you are well versed in the GDPR as well as ISO. We are all experts. In fact, we are actually trying to convert ISO 27001 auditors into data auditors under DPDPA, because that is a upcoming profession. So if you are already a lead auditor in ISO 27001, whatever you are doing, you can continue to do, but you can add one more business to your portfolio, which will be the data auditor requirements. So that is the reason why we want to give this DPDPA knowledge exclusively to ISO 27001 auditors. Similarly, on GDPR, most of you are well versed and also qualified with various CIPP certifications and other things. So for you, there is, of course, there is a need to unlearn something from GDPR before you go into this. Of course, unlearning is also required under ISO 27001 to some extent, but you should have an open mind to say that DPDPA is a different law. It is different from GDPR. ISO is a best practice and not a law. So therefore, there will be differences between GDPR compliance, ISO compliance, and then now DPDPA compliance. If you have an open mind, you can yourself find out where are the differences and then work around that. So that is the idea of this particular session. So there is nobody better than Ramesh to actually discuss this. I will request Mr. Ramesh to self-introduce instead of my introduction. So Ramesh, go ahead and introduce yourself.
Great. Thank you very much, Naavi sir. Team, I am Ramesh and I'm part of FDPPI 2 as one of the director along with Mr. Naavi. I closely worked with Mr. Naavi since, if I'm right, 2019-20 onwards. I used to conduct lots of trainings, discussions, presentations, etc. Currently, I am part of an organization called Zeiss, where we are into, I'm sure all of you know, we are into ophthalmology area, where I take care of quality, information security, cyber security, and data privacy aspects. I come with almost 3 decades of experience with IT, but working with Mr. Naavi is really a great, interesting aspect. I really enjoy. That's why I even today push myself apart from my office hours to get in work on the latest topics, etc. More than happy to be here, and I'll try to do justice. I'm trying to share only my thoughts, my experience, whatever I'm aware of, right? Whatever Mr. Naavi is going to put me a question, and feel free to participate, to share your thoughts too. Let's have this session as a kind of interactive and knowledge sharing session. Thank you. Yes, Naavi sir.
Yeah, let's start with the foundation question about where do DPDPA overlap with GDPR? Okay, and where do DPDPA diverge from GDPR or ISO? So, what are the areas of similarity? What are the areas of divergence, according to your say experience and
Great. So one is that, as we all know, GDPR is an European Union law, which is focusing on individual rights and data protection. Coming to our DPDPA 2023, it is India-specific data protection law, data privacy law, right? And third, you talked about ISO 27001. Obviously, you also talked about it, Naavi sir, in the morning session. It's a standard. It's not a kind of obligatory requirement. It's an optional, which helps us to set up information security management system in an organization to take care of CIA, confidentiality, integrity, and availability. Having said that, coming to your main question, that are there any overlaps? And obviously, there are overlaps, right? Overlapping with respect to data security and privacy, of course, right? To start with, even scope of GDPR to scope of DPDPA. Some of the things are really common. Let's say accountability. Obviously, GDPR as well as DPDPA expects organizations, you call it a data controller or data fiduciary or significant data fiduciary, to take care of the data protection, data privacy aspects of their customers, where we call them as data principal or data subjects, right? So somewhere something it differs, somewhere it definitely works in tandem. Example, consent. Obviously, both GDPR framework as well as our DPDPA mainly works on consent. Especially our DPDPA works mainly on the consent. That's where people also had a kind of initial hiccups that, oh, it's going to be a big task. A purpose, a consent. A new purpose, a new consent. So consent is the key over here more than GDPR. Then we have, like, legal basis for processing of the personal data, where in DPDPA it's more focused, right? And either you can use their data based on a consent, which is definitely needed, or for certain specified legitimate uses, where the data principal had themselves given his or her data voluntarily, fair enough, I can use their data, or for employment purposes, I can use their data, and to respond to medical emergencies, etc. Right? So, again, if you look at the definition of consent from GDPR to DPDPA, I don't see a big vast difference, where it says obviously it needs to be free, it needs to be specific to a particular purpose or an activity. You need to have a consent based on the information provided to the data principal. I'm talking about privacy notice over here. And it needs to be obviously unconditional, right? We are not going to associate any kind of hidden agenda over here while collecting the data and while collecting the consent, etc. Now look at the data principal rights. GDPR talks about almost, if my memory is right, around 6 to 7 rights, wherein here it is very simple. 4 rights we are talking about, right? Rights of the access, right to correction or erasure. However, in our DPDPA, beautifully, we have a kind of grievance redressal mechanism available for the data principal, which is not there. That's why, again, I wanted to take a pause here, wherein I had heard in multiple forums, trust me, even people always say GDPR, DPDPA is similar. At least I beg to differ, Naavi sir, as we always discuss in our FDPPI. Each law is unique, and especially DPDPA, in my opinion, is unique because the topics like grievance redressal, right to nominate, even duties of the data principal, consent manager, be with me. At least I have not come across, if I say that I have worked on, let's say, 10 to 15 laws or 20 laws. These are all really unique. So you cannot take a kind of stance saying that I worked on GDPR and the DPDPA is just kind of same and it will be easy. No, we need to apply our mind here. And we are also talking about right to nominate, which none of the other laws has got. Of course, data security perspective, it is common, right? We need to take care of CIA and little bit extension, non-repudiation to authentication, obviously. That's where ISO 27001 probably would help you and me, right? Because the 114 controls of erstwhile ISO are to the 93 controls today in combination with the 43 controls of our ISO 27701 would help us to establish to a certain extent confidently what Naavi sir talked about DGPMS, right? Digital Governance Protection Standard management system, right? Like ISMS would help you. And look at data breach notification, almost the same, right? Of course, the timings 72 hours, which GDPR talks about here, we need to wait for the kind of uh, uh, notification from guidelines from our data protection board. Otherwise, obviously, we need to look at data breach notification from any harm to the data subject. And obviously, you need to go back to the regulatory authority. In our case, it's the Data Protection Board of India or to the data principle as applicable, right? So the harm is the key word over here, which is almost the same. And cross-border data transfers, obviously, right? GDPR has got a beautiful definition, right? How can you transfer? What kind of, whether it is an adequacy decision status you need to have, or a standard contractual clauses you have, or a binding corporate rules you need to have, etc. Here also the same thing can be carried forward to see, even though we do not have a proper guideline at this stage. But I was happy to follow you, Mr. Naavi, again this morning, what you talked about, that adequacy. We need to look at, obviously data protection board is going to give us, if I'm right. Otherwise, we need to look at the criteria on what kind of data, which probably we may need to, like government data, I already talked about government to government, it may be simple, they might share. Otherwise, if it is a personal data, now what kind of data can be? And we also need to look at other regulations comes into picture, right? Whether it is an RBI, localization of data, not only RBI in India. Last week, I was participating in one of the discussion, if I'm right, in Dubai, where we wanted to launch our product, where we are talking about collecting, let's say, few data principles data. It's an artificial intelligence program again. It's going to collect, it's going to, you can pose your question, that's going to give a written answer to you. It's not going to store the data principal or data subjects data in my system. Even for that, the regulatory authority there, they said, no, you need to have these data available only in Dubai, not outside. So we are looking at a kind of creating an instance over there for Dubai operations. So we need to be aware of all these things. So these are all some of the overlaps, as well as a kind of where the divergence. But to the bottom line is, as we always talk about, Mr. Naavi, we need to be very clear about the scope, the applicability, the role of the organization, and what you talked about again, data discovery, data inventory, process-based, and then tagging it correctly, making sure the data protection impact assessment is going to be done. Where Bimesh had asked the question, right, whether this is also talking about anything called privacy impact assessment. Obviously, no. But however, with the GDPR lessons learned or experience, we can bring it over here. So in a nutshell, this is what I would say. These are all the overlaps or the kind of divergences what we have between these two. And ISO as a standard is going to help you and me to help. Because always I have the concept, please correct me if I'm wrong. Privacy is a kind of individual's perception, individual's rights. How this going to be implemented, where security comes into picture. We are talking about technical, organizational, administrative measures, what we call TOMs, through which. So ISO is a kind of enabler to implement GDPR or DPDPA is what I would say, sir.
Okay, thank you. I think Das Gupta has got some question.
Raman sir, thanks for the nice summary. I was just wondering, there is one right to be forgotten, which is there in GDPR. Is a similar thing available here? To the best of my knowledge, that similar corresponding.
We have the right to erasure, right? We have right to access, right to erasure.
Is that similar, or there is some minor
right to,
difference?
Yeah, right to erasure is also right to be forgotten, right?
There is a small difference, in my view, Ramesh. You can comment on that. Say, right to erasure is a right to ask the organization
To
to
remove,
remove
wipe.
whatever information that person has given
Correct.
for a
Right.
particular process. The
Yes.
right to be forgotten is a larger term,
Yes.
which, of course, I don't know whether it is correct. My original interpretation of right to be forgotten is that the organization should not be able to tomorrow remember that it was at all, processing a particular person's data.
Yeah.
Means that the eraser under right to be forgotten is a much larger canvas. Whereas in India, we are specifically saying that if it is required to be stored under any other law for the time being, then
Okay.
you should not do so. I think the terminology makes a
Little bit.
small difference.
Yes, sir. Yes, sir. Definitely.
Okay, fine. Now,
Obviously.
you were talking about the consent and other things. Now, you have also been dealing with the foreigners who are more accustomed to GDPR, and they are coming to India now and trying to understand the Indian DPDPA. Okay. In that context, I wanted to know what is their view on India adopting this concept of data fiduciary versus data controller. That is, do they understand the difference? Like what I was telling, that you are
Yes.
responsible, you have to take a decision. It is my interpretation. Okay. Does the foreign agencies understand that being a data fiduciary is much more onerous than being a data controller? That is one. Second thing is, when we talk of consent, we use a terminology, consent should be like a contract. Being free and other things is different. That is also there. There is a commonality there. But the use of the word that consent has to be like a contract, I'm not sure whether that same terminology is used in GDPR. Am I correct?
Yeah. Yeah.
Then that is where now we come to the question of authentication of the electronic document, which Subrayadu also has raised. That if something has to be a contract, it has to be an agreement which is enforceable in law. Enforceability of an electronic document depends upon the authentication, which ITA 2000 specifies should be either an e-sign or an electronic, digital signature. So these two aspects, that is the concept of data fiduciary versus data controller, and the concept of a contract versus some kind of an arrangement which I and you agree. What is the reaction of the international companies who are well versed in GDPR and they are only learning DPDPA now?
Oh, excellent, sir. This we had a kind of lots of discussions on this, and I am part of the global community, data privacy community. What we have, this question always comes up. My reading, my understanding, them from them is that they also recognize the fact of the definition of data fiduciaries. Believe me, they are happy that because initially I also had a tough time to explain to them my understanding to them, right? We say that it's like a trusty relationship, and then he takes the onus of their data principles data, and then he's not just going to pass it on without seeing any kind of harm or impact to the data principle. That's what the definition of data fiduciary is. What, and in my opinion, it's well received. At least a few people whom I spoke in the same community, they really say the value over there. It is not simply that guy is going to act as a kind of a middleman between you and an organization, right? To take your data and then because you have given consent, I just pump it in. Not that way. Here they are also taking the ownership, and somewhere this also helps them to interpret that data minimization in a very strongest way, because we know the definition of purpose limitation and data minimization, because you please pull in that even though if you collected a larger set of data, but for processing as applicable, only the relevant data you pull in, right? But that's what the data minimization. So from that, obviously, they are very happy, at least with whom I spoke in that community. That is one about the data controller versus the data fiduciary. Regarding the consent, at least in my scenario, right, we are all in a digital world. So any data, like me, we mainly work with, let's say, hospitals, right? Like it's very, in my opinion, I think Subraj has also touched upon in one of his question, or Deepti, I don't know. Banking sector and the healthcare sector, in my opinion, is very easy to implement because anything is digitalized over there, especially for us, it's a cloud platform. Each and everybody gets their own login, right? And they are responsible for their own data, whether it is deletion, whether it is correction, etc. All these things. That means it's happening with their explicit consent, the data processing, right? We only hold the data and we have a contract with them saying that we will, even though we are private to your data, but we will not be, applying the data, using the data unless and until. So we have very clear data processing agreement with the hospitals to say that it's going to be only for an investigation purpose, right? That too through the logs are enabled, and then we know that who did what, etc. So the consent here in our case plays a vital role, and it is digitalized. So there cannot be any kind of non-repudiation factor comes in tomorrow because it's an individual login. There is a password mechanism. There is a multi-factor authentication. There is a role-based access. There is a privileged identity access management is in place, and hence all these things. This I don't see a problem in the digital world, at least, right? Whether it is a SaaS platform or an on-premise software. But there could be a problem, obviously, how you will really collect it in each and every case if it is going to be, like you talked about it, right? Yeah, manual form is going to get digitized. Obviously, it is going to come under the DPDPA perspective. But what about the consent now? How am I going to now track it? So there need to be a mechanism. I think I can only go back to your own thought process of, right, collecting that instances in which kind of where they are agreeing, right? That also need to be available as a log file or an audit file to take care of the consent part, sir. But
Okay.
I hope
Thank
I'm answering you that there is a good understanding on the definition and interpretation of data controller versus data fiduciary. I think
Okay.
even that is emerging even in India, in my opinion, in a big way. Yeah.
Okay. Now, audience, I wanted to check whether their experience is similar because Ramesh has said that his clients, they understand this difference. Let me have any feedback from any of you, whether you had any problem in convincing a foreign person or even within India, the difference between the data fiduciary and the controller. Anybody? Okay, otherwise we'll move on to the next question. See, in GDPR, we are having these principles. There is a privacy principles, purpose limitation, data minimization, then retention minimization, accountability,
Yeah.
Accuracy. Okay, Indian law speaks about accuracy, of course. Accuracy is essential to be maintained when data is to be disclosed or when data is used for automated decision making. Otherwise, accuracy also is not emphasized as a requirement. Now, which means that if I am holding a data for purposes not for disclosure, not for automated decision making, I don't have to worry about reviewing it again and again, kind of a thing. Whereas in GDPR, there's no specific mention like that. Secondly, this Indian law doesn't specifically mention under obligations the data minimization or retention. Now, how do we as implementers bring in the concept of data minimization or this thing within the purpose limitation?
Beautiful. So my understanding, first of all, what is purpose limitation? The data is going to be processed only for that specific purpose and based on law, it's a lawful basis, correct?
How do we define a purpose? Can you just tell me what should be the components of the purpose definition? Say, for example, we said that process-based processing we require. Each process is for a purpose. Now, which means that in that process inventory, I have to add a paragraph on purpose of this process. Okay, now, can you just elaborate on how do we define a purpose? What are the elements of that definition?
Sir, let's say you go to a bank and open an account. What is the purpose there, right? I am opening an account to operate my finance, right? That is my purpose there. For which, what are all the data they need to collect or I need to provide to them, correct? To satisfy that purpose. Let's say in our healthcare, what is the purpose here in my software? Let's say the client logs in to see kind of dashboard, right? Pulls data from different applications and then see a dashboard to see that the vital parameters of a patient or etc. That is the purpose, correct? My understanding. So it need to be the data what I'm going to collect, it need to be relevant to the purpose, whether it is opening a bank account or going to out as an outpatient to a hospital, it should be relevant. As I always give an example, right? You go to a hospital to as an outpatient, let's say, what data is needed? Obviously, my name, age, my vital parameters like my blah, 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 right? They will not, like height, weight may be needed, my blood pressure. Now I am going to open an account in a bank. Will they be needing my height, weight? Not needed. It may not be relevant to that purpose is what I understand. So the data, what you are going to collect, it need to be relevant to the purpose. It need to be sufficient or adequate to what we talk about to satisfy that particular activity. And it should be very, very limited to what it is necessary. You don't have to. You remember, sir, I remember one of our Jnanavardhini where somebody presented. I really liked that case study. The bank, he said that they have taken, let's say, some 20 banks or something to open an account. Let's say a bank A talks about collecting 5 data points. Bank 2 collected, let's say, 8 data points, and so on. It was going in exponential way. So that case study brought in to say that some of the data what has been collected from the data principal or a data subject may not be needed, may not be relevant to that purpose for which. So we need to be very, very clear. This is what data minimization, in my opinion. Correct? So the data need to be collected related to that purpose. Now here in DPDPA, how can I be careful because of not having? Please, we ensure that we conduct a periodic assessment to understand, right? What kind of risks might emerge of handling this data or not handling the data. We need to have a strong policies and processes in place, obviously. And especially for DPDPA, in my opinion, because it's a gray area at this point of time, these policies should be alignment with data retention, data security, and in case of breach, what is the breach notification process? So the policy cannot be, in a kind of isolation. It also need to interact with these elements because data retention is very important. Am I going to wipe out the data that immediately somebody asks? Because my law also says you can hold the data if it is needed for another law, obviously, right? So I need to be having that tagging, obviously. Because I'm holding the data, I need to think about the security, obviously, whether it data at rest point I'm talking about. It needs to be encrypted, RBAC, role-based access control is in place. And I also need to maintain, like HIPAA talks about 6 years. I will maintain till 6 years, and 6th year I need to. So there need to be an alert system for me technologically, tool-wise. Hey, Ramesh, you need to go and delete this data. So I personally feel these kind of measures need to be placed with our DPDPA. Mainly, I think conducting that periodic, you call privacy impact assessment or data protection impact assessment or risk assessment, but that's going to be the key. That's exactly we do in ISO 27001 also, right? In 6.1, if I had to go a little bit technically there, we perform that risk assessment there. Then in clause 8.1, again, I'm performing the risk assessment. What is the difference between these two? So it is the question of reassessing the risks at the regular intervals to ensure that one, a particular risk which is on the higher side could have come down over a period of time, and vice versa is also possible. Residual risk also might erupt in a very big way. So the risk assessment is the key, right? So
Yeah.
I personally feel here also the same, sir.
Yeah.
We need to have.
Subraidu, you have got something to say?
Yes. While Ramesh sir was talking about purpose limitation, just this thought struck me because now he's been in GDPR implementation and this will be applied to India also. We are talking about process inventory, but why is it not required to have a purpose inventory also? So that the data that you have has got to be mapped to a particular purpose.
Absolutely.
Right. So without having a purpose inventory and mapping the data to the catalog of purposes that an organization have, can we say that data minimization principle has been for how do we establish that?
Correct. That's why we are saying that the process-oriented system,
Yeah.
each process has got a purpose, which
Absolutely.
means that there are as many numbers of process definitions as there are purposes. Of course, for convenience, you would like to combine a few and give one, say, umbrella purpose. But within that, for example, recruitment, if you want to simplify, you can say recruitment is a process, which includes the sub-processes of inviting applications, background verification, onboarding. I would rather like to break that, if possible, into those multiple these things, because background verification includes a processor, outside processor. Onboarding, it includes my legal department drafting a contract. It is internal, this thing. Then receiving applications, I am dealing with a non-employee. So each is actually a different process for me, so that I will be having different kinds of notices and consents, and then move it from one process to another process. Okay. I think that is one way we can try to bring. Of course, it automatically generates the purpose inventory, but otherwise, purpose inventory is relevant at the time of impact assessment itself. When you don't go into the details, just you have to tell the board that these are all the purposes for which we are processing personal
You're saying
data.
process is a proxy of purpose.
Yeah. That's what I am looking at.
He already talked about it, no, Subraidu sir. I remember at least 2-3 quickly. One, website as a process. Now we know what is the purpose of that website, right? What for we are collecting the data from the user. Email as the process, HR as the process, AI algorithm as the process. So now each process obviously going to have, as you are asking, a purpose. For that purpose, I'm going to collect the data, where that data is going to get tagged as a GDPR data or DPDPA data and so on. That's what we are promoting. Now, if you bottom up, if you collect all these processes, right? Obviously, you are coming out with all the data what is needed with the proper tagging. And we are also talking about in DGPSI process owner. So each process owner who are handling that particular data, he or she is going to become a sub DPO, what Ms. Naavi already talked about it. So this DGPSI, that first principle itself will help you and me. But I think your point is valid.
For the banking, he was talking of, for example, KYC is one process. Okay. Now, some data is collected for KYC. Now, including, he wants permission to look at my SMS or whatever is that this thing. Now, that permission should end after the KYC is over.
Yeah.
Now, if I am opening a savings bank account, there is very little information he wants. Okay. Except that the account should not be used for business purpose. Okay, that is a condition he's putting. Whereas bank may require, for example, if you are opening, let us say, a loan account or something like that, you obviously ask more questions about your credit rating and other things. So today, the banks are having the old concept of omnibus consent. That is one consent for everything, so that I don't have to go back to you for some time. I think that concept needs to completely change now.
Absolutely.
Okay. Look at what is the purpose. Define that purpose. The purpose is to complete KYC. Okay, that's all. Now, for that purpose, I need your information. I need your, say, PAN card or something like that. I need to actually send you an SMS. I need to actually take your photograph. I have a video KYC. All that is fine. And the moment that purpose is over, KYC is completed, the process is complete, then I have to stop my permissions on the video and camera and other things. So in defining the purpose, we have to look at the data minimization and retention minimization as part of that. That is the way India is perhaps going to work.
Yeah.
Now we'll go to this rights management. Okay, take the example of data subjects right, which is there in both the GDPR as well as in DPDPA. Now, what could be the major challenges we are facing in India when this data DSR or whatever is that comes into operation?
I think this, in my opinion, GDPR has got lots and lots of lessons left for us to implement it in a nice way. Right? We remember, sir, that there is one case study way back in 2018 when GDPR was launched. Microsoft opened that self-service DSR portal in its first year of operation. It's a case study. Microsoft received 18 million requests, with more than 1/3 coming from the US itself. Now, why it is so important? GDPR talks about a specific time frame, 72 hours, right? 30 days. Within 30 days, you need to solve the problem, or within 30 days, you need to go back to the data subject saying that, hey, hold on, I'm working on it, I'll come back to you. And maximum time limit provided to you is 90 days. So that means for every data subject access request, I need to have a mechanism to track when did it come, like incident management only, right? In our organizations, we have SLAs associated with the incident managements, right? So, but here it is a little bit bigger, because if you don't, it's a breach again. And it comes with its own penalty and etc., right? The data subject rights can raise it. So from there, I personally feel the challenges here, managing the volume of requests which is going to come to you. And you need to definitely ensure the transparency and accountability, obviously, right? We need to have a process in place. So I will look at the following from the GDPR. Handling the volume of data is a problem. At that point of time, technologically, they were not probably right having a sound idea. Lack of resources was the problem, whether it's a tool or people or etc. Data inventory and accuracy of the data itself was a question. Transparency and accountability, what we provide, need to be really, and regulations also evolving day by day. Now, if I take all these challenges, what GDPR had faced, and if I had to look at as a lessons learned to successfully implement in our DPDPA, I will look at, make sure that we have a strong, robust processes internally, how we are going to have, what kind of, roles and RASI chart you have.
The first point, I think, which you have pointed out is the volume of requests which may come. That means that in India also, the moment this act comes into being.
Absolutely.
Now,
so you need to have invest in technology, the tools basically, obviously.
Otherwise, the systems will crash.
Absolutely. And make sure that the people involved are given with the proper training and awareness, right? And making sure that we have, again, this is where that what we talked about again. Having a clear-cut picture on process inventory, data inventory, classification of the data, all these things would help us in establishing this nicely, right? With the tool.
This request for data access comes from the data principal, and it has to land with the designated data protection officer. Earlier, before this act came, there was a grievance officer under the Information Technology Act. Now, DPDPA talks of both a grievance officer as well as the DPO, who has to represent the company and be answerable to the queries of the DPDPA. So now, if we are looking at, which means that all these requests will come and land in the email box of DPO at so and so. Now, if this particular box is not enabled for receiving 1 million emails, obviously there will be a problem.
Big problem.
Okay. Today, even business correspondence, sometimes you say e-box is full or something like this thing. And also sometimes if the person is on leave or something like that, you have to make alternative arrangements to ensure that the emails are at least acknowledged first.
Yes.
See, acknowledgement need not wait even 30 days. So, okay, acknowledgement can be done instantly, and a number has to be given for the ticket or something like that, so that the rest of the system can be triggered. So this is going to be one of the challenges. Now, as far as this grievance officer and the DPO is concerned, what are your thoughts on whether we need two different people or the same person can done, or what is the difference between the functions of a DPO and the functions of a grievance officer?
Oh, DPO is a single point contact, right? And he's the guardian of taking care of privacy, creating a culture within the organization, making sure that all that robust policies, processes, whatever we are talking about, and the single point contact for all, right? Within the organization, within the business, for the businesses, externally to the regulatory authority, to the data subject or data principal, whatnot, right? And his or her role is really a bigger role, and they need to take care of it. Grievance redressal could be a kind of another role, right? Wherein they handle all that grievances. And in my opinion, it should not be the same, because then probably conflict of interest might emerge. I'm looking at segregation of duties over here, because these two are too different. Grievance redressal need to be really understood, that the grievance, and then accordingly action to be provided to him or her, correct? And the DPO role has been mandated, as we know, for significant data fiduciary. So obviously you need to have that role. Now for other regular data fiduciary organizations,
there has to be a compliance officer.
Compliance officer or somebody.
Okay.
Yes.
Okay, now Srijit has got some question.
So my question is like, can one person have a multiple role, grievances and
also CISO and DPO. Now let us find out. First one, Ramesh, can we have a CISO come DPO?
No way, sir. We discussed it, right? Again, it is happening. Srijit is right, because he is looking at that question from the current practice, what's happening. As we discussed, I have an experience when I was an auditor, where that person is a HR head, the person is the DPO, the person is the CISO, the person is... No, it cannot be, and it should not be, in my opinion. What is the meaning of then conflict of interest or segregation of duties? Because each role again, like a purpose we are talking about. Each role has got its own purpose with an expected outcome. Now, if I play that role, then I might dilute it. There could be a bias coming into picture, right? So many things. So it need not. It should not.
How it will be segregated? Like I'm not saying that it should be with the HR, but when it comes to like CISO may be like a compliance officer as well as a DPO also, right?
No,
so in that
only
scenario,
only Srijit sir, very quickly, CISO, right? If you are looking at from the information security perspective, he or she need to be technically sound, full stop, right? They need to be strong. When you look at a DPO, it's a legal domain. He or she need to have knowledge on the law. Believe me, that law is, we always argue in FDPPI, we say binary, right? We are from IT. Yes, no. But you know that legal fraternity, half a glass empty, half a glass full. The way of they reading and etc. So these two roles with the expertise also plays a vital role to perform that role in a very, very strong way. So I would strongly recommend it needs to be two different roles. It cannot be a same role. Like grievance redressal, for example, right? We have customer compliant manager, for example, in a typical scenario in a software organizations, right? The person, head of quality, for example, he or she receives the complaint, and then she doesn't have any bias with the business, an independent role, reporting directly to the MD of the organization, takes a correct decision, right? In favor of. Not because if you go to the business will say, no, this is not a complaint at all to start with. Then there is a big discussion. Resource comes into picture. I don't have time and etc. That's where this compliant manager role, how it is independent, in my opinion, grievance redressal officer or CISO or DPO need to be a totally three.
No, I understand that one, but my question is like this will be more skill based, right?
Absolutely.
So if the
Absolutely.
person, yeah, so the person who is maybe like in small organization, I'm not saying if
Yeah.
it is a big organization, the what you mentioned is correct. But in small organization or medium based organization, there may be a person who may be taking these multiple roles based on his skill. If he is he is good in legal also, so he can take the role of DPO also.
So you are taking a risk. Yes, sir.
Ramesh,
Yes, sir.
bigger organization, small organization is an argument.
Yeah.
Now, can the dilution of some of the provisions based on I am a small organization, will it hold good in DPP scenario?
Okay, where, sir? It will not, right? Because it's a legal obligation. You and me need to. How it will be? Now, you correctly said that when we started ISO 27001, I know so many organizations where they implemented the processes and procedures, but they have not gone for a formal audit, formal certification. Fair enough. They have processes in. That's what they wanted. CEOs said to me, Ramesh, I'm not interested in that internal audit, and I'm okay. I have process. That's okay. But in DPDPA or GDPR, we cannot do that way, right? There is nothing that I can dilute it. Now, your DGPSI, what we are talking about again, you talked about, I am going to prepare a deviation justification document, which is going to have the risks of not implementing certain processes. And this risk need to be absorbed by none less than the top management. Then they are absorbing the risk. And from the implementation perspective, the law will not allow you, right? That no, because of I'm small or medium, I can. Then it's a big. Srijit sir, are you with me? So we need to look at it.
Yes,
I
sir. So,
understand your question, but I understand
yeah,
your question.
yeah.
Yeah.
I'm just saying like no, if organization put by saying that no, we as a matter of accountability, we are actually giving an accountability to this person,
Yeah.
or the person is taking
Yeah.
this accountability. So so I think that means I just want to know like no that statement is will make the
It
compliance
will
or
not. It will not. Now, if you are coming, let's say that see, as long as everything goes pally, there is no problem. You are safe. But tomorrow something happens, a breach happens, then you and me will have fun. Correct? What we say. Now, DPDPA, as of now, it is a self-compliance. HIPAA, it's a self-compliance. GDPR, it's a self-compliance. You are going to say, hey, I am compliant. Fair enough. Now, if you wanted to say, I have put one ABC as a grievance redressal officer as well as CISO as well as I have taken care of obligations, right? But if there is a problem tomorrow, if it is not implemented in real sense, we will have a big problem.
okay.
Are you with me?
Yes, sir. So my second question is like like in certain like we have to provide a person
Yeah.
to person's personal name and details to them,
Yeah.
right? So in this whether we should be giving a like
Yeah. It is expected the DPO contact details.
and grieve
Yeah, absolutely.
and in today's level like nobody sticks long time to keep on changing, right?
Naavi sir will laugh now and then he may not like it. Don't worry about that Indian scenario. I'll tell you very quickly. I don't want to sound negative. Yesterday, I was talking to one of the senior politician in Congress in Karnataka. Okay, believe me, they have developed a tool for each constituency, which has got that entire voters database, etc. Now, this tool, like, tap, like a dashboard, it gives you. I did see that demo of the tool also. Sir, Navi, sir,
Ah,
the first question of mine to them, hey, from where you got this database? You know what they said? Interestingly, the database emerged from Hyderabad, I believe. The database of Bangalore constituency, they got it from a company from Hyderabad. Now, where is the privacy coming into picture now? My data is there with them, right? So, Srijit sir, I don't have an answer. Trust me. On the lighter side, I'm saying implementation is a big game here in India. We need to see how we are really going to go. That's why we say that like GDPR is very successful, right? That use case studies, you look at it, that finds what they are putting. So everybody is really scared, right? One log4j problem in 2021 in software industry. Wow, it shook that entire European Union. I know how people had worked during that, at that to December. Nobody works, if you know, right? Christmas time and New Year time, but everybody worked. What kind of data was available in that logs? Any, GDPR data is available. So everybody was, because GDPR is very stringent. So I hope and pray that our DPDPA also becoming like that. Otherwise, it's impossible. You will have one single person everywhere.
Now, under GDPR or
Yes, sir.
let us say ISO, is there a mechanism for grievance redressal?
ISO, there is nothing like that, no, sir. Only customer complaint, we will look at it, correct?
Okay.
ISO, as far as I know, there is nothing called grievance redressal, etc. That CISO is responsible. So somebody has got a problem, they have to raise it with them.
Okay.
Right? I remember one ransomware attack use case in Bangalore, right? Where that CISO got involved, and then they deployed a few consultants, and we all went there to really look at it, etc. That's all. Otherwise, there is nothing called, at least ISO perspective.
Okay.
Correct?
GDPR. On GDPR.
GDPR, obviously, the data subject can raise his or concern, right, with even the regulatory authority.
Correct. But is
Yeah.
there a grievance redressal mandate?
I don't think so. It's only DPO, right, in GDPR, sir? In GDPR, only the DPO.
No, but then the question is,
yes,
is
sir.
there any real difference between data subject access request mechanism and grievance redressal mechanism? After all, the data subject access request, many kind of grievances can be addressed, right?
Yeah.
Correction, right to delete, right to stop processing, and all those things, right? So, is there any difference, like controller and fiduciary? Is there any subtle difference that we are missing between the data subject access request process and grievance redressal? Or the word redressal means there is an accountability to redress it successfully.
Yeah.
Yeah, I think it's a good question.
Yes.
Now, see, and it also leads to the discussion on what should be the grievance redressal process. I think tomorrow I will be trying to address that under the.
Sir, very quickly, I'll share my thoughts because I was just going through. Grievance redressal process, in my opinion, is a structured methodology to offer a step-by-step solution for a data principle.
Yeah.
Right? Two, if they have any kind of grievance, compliance. That's why I was trying to link that compliance management process.
When that grievance comes is when there is a failure of the DSR request.
Correct, sir. Correct.
The DSR request is made, say within 30 days or whatever is the time, something DPO replies. Okay, he gives a summary and some information, which no, Mahesh is leaking his personal information. Okay.
Oh.
Okay. Now, so grievance comes when the DPO actually has resolved the issue at his level, and it is not satisfactory for the data principle. So it is a second level kind of a thing. So it is like an appeal over the resolution of DPO that may require another person, not the same DPO.
Correct.
DPO do whatever is possible until he wants to close the query. But when that is not satisfactory, the person has to, the data principal will say, I am not happy. I will to raise it as a grievance. So a grievance officer will normally be the legal person because he will look at the mediation as an objective of the grievance redressal. He will use the legal knowledge, and if he also fails to resolve, then of course the data principal will be going to the data protection board, and from data protection board the TD-SAT, and then TD-SAT to Supreme Court. That is how grievance redressal becomes more or less a part of the legal system, whereas the DPO will hold it under the customer service kind of level. Okay, Subraidu, is that a fair description? of the distinction between the.
Yeah, it looks like, but I think I'll have to go back and read it once again because DPDP has got both access request as well as redressal, both of them, right? So while I'm inclined to think that that interpretation is correct, I wanted to check whether it's a correct interpretation or so it's an over and up. So because once again, that contractual versus fiduciary kind of a thing, that data subject access request procedure might satisfy the contractual parts. Okay, somebody raised a request, I resolved within 30 days, I replied something, so I can pull out all the tickets and say, this date the ticket is raised, they gave this resolution, that cycle ends. But at the end of this entire contractual cycle, as a data principal, I could still end up uh, um, frustrated, like the Bajaj Finance phone calls or HDFC phone calls or something, right? So maybe that is where the redressal process starts, right?
Okay. Any other questions on this topic from others?
Yes, sir.
Yes.
It's not my question, like, but just like like whenever like you get a chance on the discussion, I think there should be a like a segregation of description among should be defined properly between
Obviously.
DPO and the grievances.
Job description, job
Yeah.
profile need to be there. Job description need to be there, obviously.
Yeah, and as well as the flow, like
Yeah.
as Vijay, sir Naavi sir told, like how it should go, like that should be
Defined.
because the reason is that we will not get buy from our owner, like okay, they may say, so, okay, let the HR handle this role, or let the CISO handle this role, and most of the organization will how to follow, like based on the business requirement.
Yeah, yeah.
Okay.
No, that's why that JDs plays a vital role, Srijit sir. Job description, right? Even let's say ISO 27001 also, JDs are being playing a vital role when they come for an audit. They will ask if you're a CISO, what kind of qualification you have, competence you have, skills you have, and so on. Yeah.
And another thing is in the organization, it makes a significant difference because the complaint which is with the technology department, which perhaps DPO represents, will move to the legal department. The grievance officer is more likely to be associated closely with the legal department or the compliance person. Therefore, it is a very important shift of resolution. Yeah. If the CCO doesn't like the DPO, this is the time when he will raise that grievance and pull up the DPO. Okay. Anyway.
So, sir, I have one question. Sorry.
Yeah.
So, if we implement the grievance redressal mechanism, the queries that we receive in that, should it be addressed by the legal team generally, or the respective DPOs?
No, I'm making a distinction that first complaint will have to land with DPO.
Correct.
And he will resolve it. Now
he will take care of legal.
Yeah, without
DPO is legal. DPO is legal.
Help of the legal department, he will give his resolution. Now,
okay.
The data principal, if he is not satisfied, maybe he will ask again. There will be some iteration of the request. Some negotiation will happen. But subsequently, they are not able to reconcile what DPO proposes. For example, he has given a request for correction. Let us say the data principal has given a request for correction. Now, the DPO is not willing to accept all the corrections. Okay, for whatever reason, he may say that my records show difference or something like that. Now, that is the time when it becomes a grievance. That is, a complaint becomes a grievance when the person who has raised it is not satisfied with the resolution given at the DPO level. Now it goes to the grievance department. So you may have to have a process of grievance being, say, triggered after the completion of the DSAR or the request clarification from the DPO. Okay.
Yeah. Okay.
And that is where the legal department, you see, after all, even if there is no differences between the two, it is better to actually shift to another person so that he will bring a different perspective, and the data principal also feels that he has raised it, escalated it to the next person or something like that. So instead of the DPO himself trying to break his head on satisfying the data principal, you raise it to the grievance redressal this thing, and grievance redressal has to have a documentation of whatever they are doing, because whatever grievance redressal department does, becomes the evidence for DPB.
Okay.
Whether
Okay.
it has been properly done or not, because when it goes to the DPB, DPB will ask, have you exhausted the remedies under grievance redressal under with the company? If so, he will ask the grievance redressal officer to actually give a sort of a report on what happened with your this thing. Okay. The DPO will may handle it at a more, let us say, a casual level, or let us say a more simpler level. But a grievance officer will have to immediately look at his activity as a legal activity with documented meetings, and the documents will have to be recorded with Section 63 certification, and then if it ends there, everybody is happy. But if that goes back to the DPB, then we are talking of 250 crores penalty coming out of a bad grievance redressal. Okay. Say mistake of a DPO can be corrected by the grievance redressal officer, but mistake of a grievance redressal officer may not be easy to correct. It will go to the DPB. Okay. So you have to understand this and then create the hierarchy accordingly. I think that is a requirement.
Okay. Understood, sir. Yeah.
Yeah. So look at it as a trial court and a appeal court kind of a thing within the organization. Okay. So, yeah, at a customer
Got
level,
it.
simple disposition, most of the time it will work. But if not, then it goes into documentation, documented grievance redressal. Okay.
Okay.
So the other question I was asking is grievance redressal under ITA 2000, and that perhaps I don't know whether it can be combined, because grievance redressal business activity is a legal activity. There can be only one court. Just
In many places, as of now, it is combined now, sir.
yeah.
As
So
far as I know.
grievance under ITA 2000 and grievance under DPDPA may be handled by one grievance officer,
Correct.
but not DPO and grievance. That
Definitely
has to
no.
be separated.
Definitely. Yeah.
Okay. Yeah. Is that thought clear? This is a very important, question which came up, and it is actually part of the control mechanism which you have to develop. Okay. Now, say now, in terms of documentation and record keeping, now ISO 27001, you have got lots and lots of, you can say, templates for documentation. Is it possible to make use of that for DPDPA, or should we develop a completely new set of documentation?
I think many of the things could be extended, in my opinion. That's what many of the organizations are doing also, my knowledge goes. Some of the places where it is totally new, where you don't have any reference to it, right? Obviously, it needs to be a new policy. Otherwise, that existing policy could be accommodated today to add these privacy aspects also, right? Earlier version of 27,001, if my memory is right, 18.1.4, which talks about handling of PII, personal identifiable information, which is the only reference at that time related to privacy, right, with 27,000. Of course, with the latest 2022 version, the standard itself is more focused on privacy, right, especially cyber security and data privacy. So the existing ISO policies could be, we have done immediately upgrading to suit the needs of, right? There itself, we can definitely add as much as possible, but some of the things we need to have definitely a new perspective also. For example, whether the existing risk management practices can be aligned to data protection impact assessment is a big question. In my opinion, these two are two different elements, right? Wherein risk assessment, only we are looking at cyber security and information security, wherein data protection impact assessment, harm to the data principal or the data subject. From the privacy perspective, what you talked about, 36 risks, right? That cannot be clubbed there, in my opinion. So we have a separate process. So we need to think about it as applicable.
Yeah, so you agree that there has to be a separate risk register for the privacy risks, And if possible, even if you want, this is a question which I am normally handling in this thing, whether existing policy you can also import for privacy. There is existing ISMS policy.
Right.
For example, an incident management policy. Okay, business continuity policy, whatever is that. You already have extensive documentation of that in the ISO. Okay. Now, can that be also considered as the policy for DPDPA compliance, or you should modify it and add a data protection clause in the same this thing? Or third alternative is completely a new document and create a separate documentation folder for DPDPA compliance, to the extent that if there is a common document, you better cut and paste that here, rather than saying that we already have ISMS, therefore I don't need this policy. The statement which a company can make is, I am already having an incident management policy, so I don't require one more incident management for DPDPA. Or another organization may say that I had an incident management policy. Now I am making some alterations there. I am redefining incident to include the privacy, DPDPA non-compliance issues. And in terms of the post-incident recognition activities, I am adding this particular clause that if the data breach relates to private personal information coming under DPDPA, the following action will be taken, something like that. Okay, that is a modification.
Yeah.
Or draw a separate DPDPA incident management, where you can say DPDPA incident means personal data breach, which comes under this, and it will be reported 72 hours immediately, whatever is that. So entire process can be rewritten in the case of DPDPA. Now, what do you prefer if you are the person who is in charge of such an activity?
I'll tell you, sir, my reading. What I'm talking about is the current situation, right? Especially from Indian perspective, that many of the organizations are adhering to many of the process improvement frameworks, whether it is NIST framework or ISO framework or CMMM, COBIT framework, right? SOC 2 compliant, etc. What our thought process here is trying to go towards an integrated management system as much as possible, because otherwise it's very, very difficult for you to maintain, even establishing first of all, then implement it, then check that effectiveness at regular intervals and so on. So that integrated management system concept is really helping to, right? Now, but of course the privacy, we had only, let's say, HIPAA as one sample earlier. And of course, from 2018, little bit more on GDPR. Today, 140 plus laws we are talking about. So there could be, in my opinion, what you talked about, data governance protection management system, right? DGPMS could be established as a separate system, have a kind of references to where applicable. That is one way. But what currently happening is, at least go quickly, dirty job, what we say, right? Quick and dirty system. Clean up that existing policy to accommodate what is my main requirements today. That is one way. But let's say consent manager. Obviously, you need to have a new process. You don't have anything earlier to talk about it in any one of the system. Or we have a disciplinary process, for example, right? We clearly say that offer and the condition terms of the employment that, hey, you need to follow my process. Otherwise, there will be a disciplinary process invoked. There I can go and say, add the new requirement of DPDPA, data subject responsibility there. Possible.
So in terms of managing that change of documentation, okay, as a practitioner, are you comfortable with making corrections? Because tomorrow the question will be, who was the owner of that particular document? There will be a IS person. And now you make changes in that, you have to get his permission. Tomorrow you want to make some changes in the privacy area, you have to go back to the CISO and his person and try to make a change. Will it not introduce more complications than creating a whole new set of this thing?
It is. For example, today I will tell you the real example. When we are launching a product in US, let us say, right? USA, FDA comes into picture. It talks about cyber security aspects, and not only at the time of developing and then rolling it out to the commercial, right? Commercialized operations. While that software is used, right? What we call, we need to keep on looking at that software for any kind of new vulnerability or new threat from the cybersecurity perspective. Post-market surveillance, what we call. Now, so far, this was handled by a quality department with their limited knowledge. Today, cybersecurity is becoming a bigger game. FDA had come out its own 81001-5-1 standard, which talks about cybersecurity, how to handle. That means this cannot be handled by a quality person, as you correctly mentioned. That means cybersecurity folks have to come into picture. Now, what had happened? Just as a kind of quickened operations, the existing processes they have accommodated with the help of some subject matter experts. But today, they realize the need of having a separate process, how to handle information security and cyber security and privacy risk as a separate process. It's just emerging. It is emerging.
Agreed. In fact,
Yes,
this is
sir.
what we are recommending, but it's always difficult to convince an existing company to make such a
Absolutely.
change.
What Srijit sir talked about, right? He's talked about even at the roles level, they have clubbed it. Now today we are talking about, no, please have a separate system. It's a big game to convince people, and then it will take time, sir. But I will go with you. We need to have a separate system.
One last question. Now, say most of these information security managers create a steering committee or something like that who to guide the rest of the people. We are also talking under DGPSI, a governance committee. Okay. Now the composition and say once you have an information security steering committee, now that is developed on ISMS principles, and whenever there is a cyber security issue, there are certain responsibilities for this committee. Legally speaking, I can draw the attention that under the Section 70 notification under Information Technology Act, if a particular system is declared as a protected system, like many of the bank systems today are declared as protected systems, the representative of the CERT-in should be there in the Information Security Steering Committee. This is a law. Okay. Yes. Now, if you want to implement the data protection now, is it better for me in the organization to have a separate data governance committee and not mix it up and say for convenience, the Information Security Steering Committee will also be the data governance committee? If that is an easy option, but I feel there is a problem there. What is your view on that?
Excellent, sir. Data governance committee need to be separate. We already have, as I told you. I am part of that at the global level, wherein they look at it. Obviously, there is an interaction has to happen amongst these guys at the process level, at a tool or technology level, and regulatory requirements level, etc., which is happening. But it cannot be merged together as a single. Then we will be into bigger trouble. Again, as we discussed, bias or conflict of interest and so on. Yeah.
Any other questions from the audience? I think we have had a very fruitful discussion and on a wide variety of topics. And because Ramesh is closely associated with me on the DGPSI also, we were able to combine the GDPR and other things along with what we otherwise recommend also. Now, I would like to have any more questions before we wind up the session. Pratyush, Mr. Krishna, Indrajit. Okay. So if there are no questions, should we wind up, Ramesh?
Yes, sir. Yes, sir. Great, sir. Thank you very much, really. Team, all the best for your course with Mr. Naavi. And please be part of FDPPA. You would have seen the kind of expertise all are, specialist people, I would say, people like Subrayadu sir, Ashokini, Karadi, Bimesh Karadi sir. So please be part of FDPPI. Let's build a strong privacy culture. Thank you very much, really.
Thank you. So
Certainly, sir.
Tomorrow
Thank you, sir. Thank you. Bye-bye.
Thank you, sir. Thank you, sir. Thank you.
Thank you.
Thank you, sir. Bye.
Bye.